So welcome everyone. Welcome first and foremost to the 6th annual conference of the Refugee Law Initiative. It's great to be back. My name is Cornelis or Kees Wouters. I am with UNHCR, the Senior Refugee Law Advisor. I'm stepping in for my colleague, Dr. Madeleine Garlick, who unfortunately is not able to moderate this session. Welcome, therefore, welcome to this session on external processing, regional approaches, responsibility sharings, and pathway to protection. I guess I couldn't have asked to step into a more topical issue or session on a more topical issue than this one. External processing, while dating back several decades, clearly is a very topical issue and very current issue at the moment. It's at the forefront of many political and legal debates around the world, but particularly, I guess, in Europe and even more particularly in the United Kingdom. This panel, and I will not take too much of your time as moderator, but this panel is aiming to focus or explore whether and how external processing can play a protective role in addressing some of the challenges that we are facing around asylum and international protection, including pushbacks at borders and other border restrictions, mixed movements, onward movements, and returns of rejected asylum seekers. We have 4 experts with us today on the panel. Each will give a presentation, after which there is time for questions and answers. I will shortly stop my video, but if you see my face popping up, it means that each speaker is in his or her final minute of the presentation. If you have questions for the panelists, I encourage you strongly to put them in the chat, and then I will summarize them or repeat them once we are at the Q&A part of this panel. For everyone listening in, please keep your microphones muted and your videos off. With that, I am happy to introduce the very first speaker of this panel, Ms. Riona Moodley, a lawyer from Australia, a lecturer at the University of New South Wales in Sydney, and a PhD candidate and research affiliate at the Caldor Centre for International Refugee Law, again at the University of New South Wales in Sydney. Riona, the floor is yours.
Thank you, Kees. And thank you everyone for joining. Before I begin, I'd like to acknowledge the Gadigal people of the Eora Nation, the traditional custodians of the land in Kensington, Sydney, from where I meet you, and pay my respects to their elders past and present. Over the last 3 decades, consistent steps have been taken by countries in Europe to introduce externalization practices that seek to contain and/or deter people seeking asylum from entering the EU bloc. The fallacy, however, that such practices can prevent large movements of people entering Europe came to light dramatically in 2015. When over 1 million people entered the EU irregularly in search of safety, and over 5,000 died while attempting the journey. With its supranational asylum system and robust human rights framework, the EU was then, as it is now, uniquely placed to show leadership to achieve international cooperation on refugee protection. And yet, despite the strong humanitarian and political imperatives to do so, a coordinated response never came. By the end of 2016, it became apparent that the real crisis was not the number of people arriving in Europe, but rather the failure of states to share responsibility to provide safe, accessible pathways to protection for those in search of it. Notwithstanding the EU's vastly different response to the Ukraine crisis this year, an exploration of which is beyond the scope of my talk today, the unfortunate legacy of 2015 remains. Despite the generosity shown to those fleeing Ukraine and the swift action taken by the EU to trigger its temporary protection directive, European states continue to harden their policies towards people from other parts of the world. Drawing inspiration from Australia's offshore processing model, attention has again turned to what role external processing might play in the management of irregular migration to Europe. Now, controversial plans to process asylum seekers outside Europe as an alternative to the reception and processing of asylum claims within the EU were considered in the past. None, however, has gained the necessary political support to progress further, at least at the EU level, due to concerns over compatibility with the EU and international human rights law framework. Now, although the term external processing or extraterritorial processing has become synonymous with the types of deterrent practices led by Australia and more recently the UK and Denmark, the concept can in fact be applied more broadly to describe a range of practices where claims for international protection are examined to some extent outside or before the arrival of the asylum seeker in the intended destination state. In this way, the term is not limited to forcible removal and transfer arrangements after arrival in the destination state, but might also encompass a range of pre-arrival practices that seek to expand refugee protection. This includes, for instance, the use of protected entry procedures, the issuing of humanitarian visas at embassies, as well as processing under UNHCR's resettlement program. It is these types of pre-arrival procedures that will be the focus of today's panel. In the context of large and protracted refugee situations, external processing might also include the possibility of expanded and targeted resettlement through region-wide processing frameworks in key transit countries and regions of origin before arrival in the destination country. It is this particular subset of external processing, which I refer to and conceptualize in this talk as regional processing, that I would like to explore with you today, and also its potential use as a complementary pathway to protection in Europe. In stark contrast to the deterrent practices implemented in Australia, the central goal of regional processing as conceptualized in my talk is about sharing responsibility and improving access to protection, not hindering it. Relevantly, the concept envisages several states entering into an arrangement, typically a multilateral one, to process asylum seekers in a particular country or region that is or is at risk of being overwhelmed with large numbers of people seeking international protection. Within an EU context, regional processing might also include the possibility of the EU and its member states engaging with two or more non-EU neighbours to establish processing facilities in third countries, or to send EU delegations to key transit countries where the protection claims of asylum seekers can be efficiently processed and regular entry into the EU facilitated. Provided that such idea is implemented as a complementary pathway to protection, not an exclusive one, in theory, regional processing has the potential not only to address immediate humanitarian and protection needs, but it might also help ameliorate the real risks associated with onward movement by creating complementary pathways. At a bare minimum, however, for any of this to work, it would require not only international cooperation and political will from EU member states, but firm commitments to respect key international law and human rights law principles, notably the principle of non-refoulement. While a protection-oriented approach to regional processing might sound like an unrealistic proposition, similarly ambitious plans have succeeded in the past. The Comprehensive Plan of Action for Indo-Chinese Refugees, which I discussed at last year's conference, was implemented with qualified success nearly 40 years ago, when over 65 states, together with UNHCR and other human rights organizations, collaborated to resolve the Indo-Chinese refugee crisis impacting Southeast Asia in the 1970s and 80s. While far from perfect, the CPA does offer lessons on how a principled and pragmatic approach and response to large refugee movements might be preempted in the future and managed more effectively. As UNHCR has previously noted in its 2010 policy paper, regional processing might be appropriate in the event of mass influxes of protection claims being made in several states, but arising from the same situation or particular migratory routes, or where there is a concern about managing responsibility for asylum processing and solutions more evenly between states. The scope of processing could also be more or less extensive depending on the situation and the stakeholders involved. For instance, while regional processing might involve RSD procedures and reception arrangements carried out jointly under the supervision of UNHCR, states could also adopt different roles and responsibilities consistent with their capacity. Such arrangement might also expand the forms of durable solutions available and include orderly departure programs in countries of origin, protected entry procedures in host countries, student visas and labor mobility programs, to name but a few. Within Europe, regional processing need not be limited necessarily to exceptional forced migration situations. In theory, it could be implemented to create regular pathways to access international protection in Europe, and that is to say, it could be implemented as part of a long-term EU strategy to manage irregular migration movements from particular countries or regions of origin. The efficacy, however, of such arrangements would depend on the EU providing real alternatives to irregular onward travel. Moreover, to be legally feasible, such arrangements must be made without prejudice to the right to seek asylum on EU member state territories. Given the political challenges that ensued during the 2015 and 16, one might question whether such idea is capable of being pursued in the current political climate. My response is this. First, the EU's Ukraine response is certainly promising in demonstrating that the EU has the capacity and political will to act swiftly and generously. Secondly, let us assume that humanitarian grounds alone will be insufficient to move EU member states to act when it comes to migration from the global south. My argument, however, is that the failure of the EU to act in 2015 and the legacy of political instability that has ensued as a result should be incentive enough for reconsidering its approach to future movements. Moreover, in a post-COVID world where both unskilled and skilled migrants, irregular or not, are sorely needed in Europe, there's little downside for the EU facilitating access to protection for people in search of it and providing them with economic opportunities to rebuild their lives. The multilateral formulation of regional processing put forward in today's talk stands in stark contrast to models based on containment and deterrence. While states have a legitimate interest in managing irregular migration, actions taken to address them must be premised on a commitment to international cooperation, responsibility sharing, and most importantly, respect for human rights. With its comprehensive common asylum system and constitutionally enforceable human rights framework, the EU is in many ways uniquely placed to show leadership on how to manage irregular migration in a protection-oriented way. The newly created EU Asylum Agency could help further this objective. Since many European states appear set on introducing external processing in their toolkit to manage irregular migration, it is my view that refugee lawyers and human rights advocates must engage constructively with the ideas being considered by states so that we might help guide how they are framed. Whilst regional processing is by no means a panacea for managing irregular migration and protection issues in Europe and elsewhere, such idea does, however, offer an opportunity to shift current politics and introduce both pragmatism and principle to asylum policy. Thank you.
Thank you, Riona. I didn't even have to switch on my camera. Thank you so much. I again encourage all participants to pose questions to either Riona based on her presentation or to any of the other speakers, or general comments or questions around the issue of external processing. It's now my pleasure to turn the mic and camera to Dr. Nick Faith Tan from the Danish Institute for Human Rights, a well-known expert on this issue. He will be speaking to you on 3 forms of external processing in law and practice. Nick, the floor is yours.
Thanks, Kees, and thanks, Riona, for a fantastic first intervention, which does a lot of the work for me, in fact. My intervention today is based on some joint work in progress with Paulina de Oliveira, who couldn't join us today, on the law and practice of external processing. And just to foreground my intervention here, I mean, I think we'd all agree that the state of territorial asylum and access to territory in the global north is under extreme pressure. I saw last week the UN Special Rapporteur on Migration reported 1.6 million persons have been summarily returned from the US alone under Title 42. The DRC, of course, documented 12,000 pushbacks at EU external borders in last year alone, which is, of course, a fraction of what is really occurring. And as we know well, the UK-Rwanda agreement and Danish legislation seeks to externalise asylum responsibilities for those people who arrive in destination states and are transferred after that arrival. And of course, these forms of pushbacks and externalised asylum systems are addressed by the RLI Declaration on Externalisation and Asylum, launched yesterday at this conference. And of course, the purpose of this panel is to turn to perhaps the next question, which is whether some forms of external processing could be envisaged as protective and usefully proposed in this time of extreme pressure on territorial asylum. So with this background in mind, Paulina and I also define external processing as fairly broad, as an umbrella term for the pre-arrival determination of the need for international protection by the authorities of a destination country or region in a third state. And this definition clearly builds on Riona's really useful work on regional processing. Our work is also inspired by Ayelet Shashar's seminal work on the shifting border, which puts forward a vision whereby core human rights obligations should follow border control on the basis of a functional approach to extraterritorial jurisdiction, and the link between territory and protection should be minimized, thus diminishing the fixation on territorial access as a precondition for securing refuge. So in our working paper, Pauline and I examined three forms of practice that fall under the banner of our conceptualization of external processing. The first, of course, is humanitarian visas, which allow an individual to approach a potential asylum state outside its territory with a protection claim, and if prima facie found to be needing protection, be granted entry to that country. And recent practice here includes, of course, Brazil's well-known humanitarian visa scheme for Syrians, Afghans, and Ukraine. Perhaps less well-known, the US's Central American Minors Program, which provided asylum seekers under 21 the potential to be assessed in Central America by US officials, and if in need of protection, granted access to US territory. And of course, until 2012, Switzerland had its own standalone institutionalized humanitarian visa scheme at embassies globally, allowing for applications independent of territorial access. Of course, the problem we see with humanitarian visas at present is concerns related to fear of numbers, that a humanitarian visa mechanism allowing a visa claim by anyone, anywhere, would overwhelm both embassy, but even national asylum systems. So what we see is humanitarian visa schemes tend to focus on a very specific group of applicants with narrow eligibility criteria for certain groups of people. A second obvious concern around humanitarian visas is, of course, that according to recent European case law, a state's extraterritorial jurisdiction is not triggered by the mere processing of a visa application, thereby placing humanitarian visas in a discretionary policy realm rather than a protected international human rights legal realm. The second example of external processing we look at what might be broadly termed emergency evacuation schemes, allowing for the immediate rescue of asylum seekers in imminent situations of risk. These, of course, occur in response to specific crises and often include a combination of both in-country processing and processing in countries of transit. So a recent example of evacuation would be the large-scale mechanism, rather haphazardly implemented by the US following the rise of the Taliban, the return of the Taliban in August 2021. We saw 82,000 people being evacuated from Afghanistan by the US alone, and thousands more by the UK and EU member states. I think also the UNHCR's emergency transit mechanisms in both Niger and Rwanda could be encompassed under this heading, and Laura will of course speak to the ETM Niger experience. The third concept we look at is perhaps most closely related to Riona's intervention, and that is the idea of pre-arrival processing en route to a destination state. And this may occur in a facility or a centre. So in Europe, of course, there's been a long line of proposals for this form of external processing, as well as more deterrence-driven approaches, from the UK's 2003 New Vision to French, Italian and German ideas for centres or hotspots in North Africa. Now, of course, it's important to point out that at present, pre-arrival external processing is essentially a theoretical discussion. But we argue that there are important lessons to be learned from more deterrence-driven approaches. And these standards would include avoiding the use of detention, a secure legal status in the host country during the externalised asylum procedure, solutions for refugees beyond the asylum procedure itself, and of course, close coordination with the territorial hosting state to ensure the effective return of rejected asylum seekers to country of origin in full respect of their rights. And I think Laura will speak to this as well. So they're the three categories or examples of practice or proposals that we address. And of course, in many ways, they range rather different human rights, legal and policy questions. But in my final minutes here, I want to address three cross-cutting issues that we see with all three approaches. The first, of course, is the relationship between an external processing model and subsequent territorial asylum. So as we already mentioned, while in an ideal world, external processing would be entirely without prejudice to the right to seek asylum, subsequently in a destination state, to my mind, at least, governments will be rather sceptical of the concept if such an approach only results in a greater number of refugees. Any external processing model is likely to have as an objective the contribution of a decrease in irregular arrivals at external borders. Now, of course, Rion is correct that as a matter of international law, external processing cannot wholesale replace the right to seek asylum on a state's territory. However, we would argue that the individual may not always be entitled to a full asylum procedure following being screened out or rejected at an external processing facility. So where an asylum seeker, for example, has already been through a fair and efficient external procedure with procedural rights and guarantees, including a right to appeal, and subsequently and soon after applies for asylum in the territory of the same destination state, an accelerated screening at the border may be sufficient. And such a screening could be narrowed down to an assessment of any new risk since the externalised procedure. The second cross-cutting issue is, of course, the question of the application of human rights and indeed EU law to any future or current external processing scheme. The current status quo, of course, is that in the schemes we see presently incorporated, there is an absence of human rights law protections and obligations accompanying such schemes. From a protection perspective, clearly the application of extraterritorial jurisdiction and therefore human rights obligations flowing from that to external processing is highly preferable. In our view, however, irrespective of whether extraterritorial jurisdiction is established or otherwise, there are a set of minimum procedural rights to external processing to operate in a protective, sensitive way. And these are, of course, the respect for non-refoulement, access to a fair and effective procedure, including a right of appeal, freedom from arbitrary detention, and, of course, safeguarding the safety and security of individuals during the procedure itself. Thirdly, and finally, a cross-cutting issue we identify is the crucial importance of international cooperation and indeed responsibility sharing between the externally acting state and the territorial host state. So we would here envisage the finalisation of a formal agreement between the cooperating state countries to establish clear lines of legal and operational responsibility with respect to reception, accommodation, security, and cooperation on return. Clearly, of course, any externally processing model would need to operate in complementarity with the territorial state's own national asylum framework. And this, of course, is vital to prevent damage to perhaps emerging or newly established national asylum systems, to ensure that the external processing site does not become a magnet for asylum claims, overwhelming the host state, and indeed to ensure that there is equitable access protection for those who need it. I'll stop there. Thank you very much.
Thank you, Nick. And once again, you had a minute left, so thank you for keeping to the time. Again, I would like to emphasize to all participants, if you have a question or a comment to make, please start posting them in the chat so that we can collect them, and then when we are going to the Q&A, I can put them to the panelists. Moving forward, I'd like to introduce now or give the floor to my colleague, Cameron Shilton, who will speak about UNHCR's view on regional or external processing. Cameron, you have the floor.
Morning, everyone, and thanks for the opportunity to take part in this panel. Thanks, Case, and certainly thanks to Riona and Nick for those wonderful presentations. I'm frantically trying to think of somewhere I could disagree with you on, but anyway, I've been asked to say a few words on UNHCR's view on regional processing, and I'd register a couple of caveats on that score at the outset. So first, although UNHCR has taken clear positions on various state practices and policies that have come to be bundled together under the rubric of externalization, and does have long-standing public positions on related issues such as interstate transfer arrangements, the use of safe third country concepts and the like. UNHCR hasn't pronounced itself in any great detail in recent times, specifically on concepts of extraterritorial or regional processing, which are the subject of this panel. So while I'm certainly not here as an independent critical commentator, and what I'll say will draw on past and current UNHCR positions, it's not intended to be a statement of UNHCR's settled views on every point. And then to dispense briefly with a few questions of terminology and scope, I'll be using extraterritorial or external processing, largely in line with the previous speakers, and more or less in their dictionary sense, to refer simply or neutrally to the processing of the whole or some part of a claim to international protection by one state on the territory of another, but a little bit more particularly where it's proposed to do that at scale, and to put in place specific infrastructure or facilities for doing so in a host country. And that could be either in a transit location, I guess that version lining up with sometimes what's referred to by states as well as some of the other panelists today, in particular Riona, as regional processing, or follow transfer from a state of arrival, or some combination of both. And I won't be directly addressing situations where some form of extraterritorial processing is entailed by emergency evacuation arrangements, which Laura will talk about, I understand, shortly, or other ad hoc measures for specific populations, or shipboard processing, processes for resettlement or a humanitarian admission, embassy procedures, or those sorts of things. Although, of course, as we've heard, each of those does present analogies and disanalogies with the more specific idea of extraterritorial processing at scale. And so, as we've already heard a little bit of mention of, the very mention of extraterritorial processing has rather uncomfortable resonances for many of us, calling to mind various well-known past or present state practices or proposals, some of which have already been pointed to, which have by design or default frustrated access to international protection, compromised refugee protection standards, resulted in serious human rights abuses, undermined international cooperation, or simply been ineffective or impossible to implement. And UNHCR has been very clear that such policies and practices, which we've broadly come to refer to as unlawful externalization, are inimical to states' refugee protection responsibilities. But at the same time, UNHCR has repeatedly underlined both the human costs and the challenges to states that are raised by onward movement in dangerous and illegalized conditions, and the need for safe and legal means, particularly in this context for asylum seekers, of accessing international protection. And I guess there's no getting around the brute fact that such safe and legal pathways to become a reality at any significant scale require some form or other of extraterritorial processing. And some might see any suggested distinction between externalization and more positive notions of extraterritorial processing as a little bit of equivocation. Quite obviously, the two things do shade into each other in some sense, and various proposals, practices, or interstate arrangements can be cast one way or the other, depending on one's views of their feasibility, their lawfulness, underlying policy motivations, the actual or probable empirical realities of implementation and consequences, unintended or otherwise, the effects on the rights of individuals and their ability to enforce them, the proper bounds of state prerogatives to seek to manage so-called irregular movements, the agency and choice of forum that ought legitimately to be acknowledged and afforded to asylum seekers, the extent to which any given arrangement supports or undermines respect for refugee law or the development of asylum capacity, an understanding of the timescales and investments realistically required for a proposal to be made workable and consistent with international standards, and broader impacts on the sustainability of refugee protection, of the refugee protection regime globally. All that said, UNHCR has for some time been prepared to acknowledge in principle that in certain circumstances and with appropriate safeguards, extraterritorial processing arrangements might play some role in reducing the need for unsafe onward movement. And those sorts of statements have typically been accompanied by strong cautions that first, in many circumstances, it'll be preferable if the aim is indeed to improve access to protection and solutions, to focus efforts on established third country solutions and complementary pathways, such as resettlement, humanitarian admission, family reunification, labour mobility or education pathways and the like, alongside reinforcing capacity for improved conditions and access to protection in host countries, in line these days with the GCR. And secondly, extraterritorial processing arrangements can't be seen as a panacea, as Riona already mentioned, for meeting international protection needs or migration management challenges. Rather, they'd need to form one element in a more comprehensive regional responsibility sharing approach. So what might the essential prerequisites to an extraterritorial processing arrangement be that might stand a chance of increasing rather eroding access to international protection? And here I think I'm going to find myself on quite a few points in furious agreement with Nick again. First, real international consultation and cooperation. So the needs and interests of host countries, communities and regions would of course need to be fully taken into account. And in that context, I should say that burden and responsibility sharing is more than a market exchange of asylum seekers for resources or other inducements. An extraterritorial processing arrangement would ideally have a positive impact on refugee protection in the host country, the region, and in the non-territorial states involved. Next, recognition by all involved that the impact of extraterritorial processing arrangements on unregulated movements of refugees and migrants is likely to be unpredictable and quite possibly minimal. Careful planning, resourcing and implementation, which is to say that knee-jerk proposals imagined as a sort of universal solvent to migration management challenges in destination countries are of course on historical precedent extremely unlikely to be workable or capable of upholding necessary safeguards. And the division of responsibilities between all of the states involved, as well as the rights of asylum seekers subject or benefiting from extraterritorial processing, would need to be clearly and precisely formalised. That would include clear stipulations of the applicable substantive and procedural standards and the legal framework by reference to which they could be enforced. I'm not going to dwell here on the legal standards, safe to say that the 51 Convention, of course, together with other applicable refugee and human rights instruments, would provide the baseline standards. And beyond that, perhaps the least that could be said is that if the proposed standards for extraterritorial processing differ markedly from those which would apply territorially for a state seeking to promote an arrangement, the bona fides of that arrangement's burden and responsibility sharing character might be seriously open to question. And in that connection, arrangements would need, of course, as I think Nick mentioned, appropriate legal status and reception conditions, not involving unnecessary liberty restrictions during processing. Careful consideration would need to be given, in particular, to the sustainability of arrangement and its likely effect on the national asylum system in the host country. Would a parallel system be created? Would capacity development of the national system be disincentivized? Those sorts of questions. And a big issue, of course, it would be the level of commitments by participating destination countries, so to speak, to providing protection and solutions on their territory for those screened in or found extraterritorially to be in need of international protection. And such commitments would need, of course, to be significant enough to demonstrate a genuine responsibility sharing objective and to present credible alternatives to dangerous onward movement for potential beneficiaries. But on the other hand, an open-handed commitment to protected entry pathways to all comers would be attractive to no destination states and would likely raise fears of creating pull factors for host states. In addition, the criteria for benefiting from access to protection and solutions in a destination country would need to be transparent, fair, non-discriminatory, probably involve prioritization for vulnerable groups, and might need to align in some manner with resettlement criteria, or at any rate, we might want to say that extraterritorial processing shouldn't be implemented as a large-scale discretionary alternative to meeting resettlement needs. And last, as has already been mentioned, but it's a very important point, solutions for people who are extraterritorially screened out or as beneficiaries or found in a substantive extraterritorial status determination procedure not to be in need of international protection would be an essential component, and that would need to involve both return and, where relevant, access to other migration, humanitarian or in situ regularization pathways. And lastly, of course, a few others have mentioned it, but bears repeating, processing arrangements couldn't, as a general matter, legitimize arbitrary restrictions on access to territorial asylum in destination states. So even this high-level sketch, which is very far, of course, from being comprehensive, shows just how much investment, planning, and goodwill would be needed to make an extraterritorial processing arrangement work. I see Case on screen, which means I've been not being competitive with the others in terms of keeping to the time limit, so I'll skip ahead and just say that nonetheless, benefits could potentially be enormous for significant numbers of people in need of international protection who might otherwise face stark choices between remaining where they are or facing the risks involved in taking matters into their own hands by moving onwards, if indeed that choice is available to them. So is it the right time to revisit once again notions of extraterritorial processing, given their less than noble past and present risks of abuse or ineffectiveness? Is there a good reason really in the current climate to resurrect debates around proposals that are now in one incarnation or the other at least 35 years old? The answer might be a rather cautious and heavily caveated yes, but the vision, I'd have to say, remains ideal and aspirational for now, and very significant demonstrations indeed of good faith and the right kind of political determination, including a willingness to abandon narrowly focused and counterproductive deterrence paradigms and to make substantial protection-oriented investments in regions of origin would need to be shown by states before any real-world model could be seriously contemplated without giving occasion for a bit of pause. Thank you.
Thank you, Cameron. And sorry that you had to see my face. I'll quickly go over to the last speaker of this panel, Laura Lambert of the Max Planck Institute for Social Anthropology in Germany, who will be speaking, I guess, about a very concrete and current example of extraterritorial external processing. So Laura, the floor is yours.
Thank you, Kees. Thanks a lot also to Nick for setting up this panel, and to Sarah Singer, who's doing the background work here. I'm really happy to have this opportunity to exchange with you. I'm just quickly setting up the PowerPoint. And as already mentioned by both Nick and Cameron, emergency transit mechanisms or emergency evacuations can also be considered a type of extraterritorial processing. And I'm going to dive now into the Libya-Niger emergency transit mechanism, which was created as a particular solution for, sorry, I'm just gonna make it small, as a particular solution for refugees stuck in Libya. So there was a severely limited access to protection in Libya and severe human rights abuses and detention practices in Libya, as well as migration control in Libya supported by the European Union that blocked effectively escape routes via the Mediterranean. So in this political context, that was also really, that had very high political stakes, both for the European Union and the UNHCR. The UNHCR proposed to establish such an emergency transit mechanism from Libya, and it found Niger to, as a partner state, actually as the only one. And since 2019, also Rwanda joined in. Then there was funding by the European Union Trust Fund for Africa provided to this project. And the project was thought to evacuate 3,800 potential refugees with vulnerabilities from Libyan detention centers to Niger as a transit state to have their asylum and resettlement processing being conducted there. So what I did was an implementation study in Niger in 2018-2019 and update distance interviews in 2021. So as the anthropologist here in the room, I'm going to dive into some of the challenges that could be observed on the ground in Niger. And I hope to contribute to these very critical points we have already heard in the previous presentations. Let me just start shortly with a bit of a legal and institutional framework we can perceive in Niger. So asylum in Niger, in contrast to Libya, Niger is signatory to the relevant refugee conventions, and it has a domestic legal and institutional framework for refugee protection since the late 1990s. But individual asylum remained quite marginal until the start of the ETM in 2017. So there were only a few dozen asylum applications processed every year. And importantly for the ETM, there is a memorandum of understanding between UNHCR and Niger. So I think if we follow Nick's typology that he developed in 2018 in this article, we can see that the ETM actually falls under exclusive partner state jurisdiction. So it's not the European Union responsible in legal terms, but it's only Niger. And the Nigerian administration was importantly involved in the refugee status determination and also in immigration decisions. So that's here on the right picture, for example, is a police officer processing visa applications for ETM evacuees. And this original setup of the ETM is important because it was shifted only shortly after the project was established. So here on the first line, you see that the original idea was that the UNHCR would conduct interviews and also the evaluation of the cases, but then the adjudication would fall to Niger as well as the administrative review. However, only 6 months later, this was already amended in an agreement between UNHCR and the Nigerian government. So instead, now UNHCR became responsible for the adjudication itself, and only in case of a negative UNHCR decision, then Niger would adjudicate these cases and also potential administrative review issues would follow. So we see an important shift to what could be called UNHCR mandate RSD. And the reason for this was that the UNHCR perceived the RSD in Niger to be too slow. As I mentioned before, there was a very low capacity of individual asylum processing. And of course, suddenly an administration cannot process 1,000 applications if it was used to a few dozens before. So because of the high political stakes of the project, the UNHCR decided in agreement with the government to shift this main responsibility for the adjudication to UNHCR. However, on the ground, local bureaucrats were not really informed about the scope of the agreement. In 2019, basically all ETM cases were processed by UNHCR and only the negative ones were given to the Nigerian administration. And when I discussed this with the Nigerian bureaucrats, they were really dissatisfied with this shift because actually they saw it as a sovereign task that in Niger, asylum processing should also be conducted by the Nigerian administration. In fact, their government had initially rejected European ideas of a hotspot in Niger because it said, well, asylum immigration decisions are a sovereign decision, so we should take them on. And this caused a lot of frictions and even a potential end to the ETM, which was negotiated in 2019, but then the ETM was still prolonged. So that's, I think, an important issue where we see a lot about these power relations. I think there was already a question in the chat, but the power relations between UNHCR and these partner states are really asymmetric as well. And in the course of the implementation, and can lead to an important disempowerment of Nigerian state officials in that case. And now the second case I want to mention today is the one of rejected cases. The Memorandum of Understanding detailed that Niger remained responsible for rejected cases, but it only framed them as exceptional cases. So in case people were rejected by resettlement countries or the refugee status, they could still receive a residence title in Niger or even be deported to their countries of origin, for example. But now in the process of the implementation, there were many more rejections than initially expected. So in mid-2019, about 5% of all evacuees actually had a looming rejection. It concerned 100 complex credibility cases that I mentioned here, and 20 very complex cases who were seen to be in international criminal networks. So they were former smugglers, they had tortured other migrants in Libya, and even maybe during their military service, for example, in Eritrea. So these cases were much more numerous than expected, and people like local actors on the ground told me that this was also due to the setup of the ETM with its 3 different stages that had different conflicting logics. So the first stage was an evacuation from Libya based on mostly vulnerability concerns. Second would be the RSD in Niger based on a perceived fear of return to the country of origin. And the third logic would be a resettlement logic following again resettlement country interests. So these 3 stages followed each other, and they had different standards of operation and selection. And as a result, people were evacuated to Niger from Libya, who would then not receive the refugee status or who would also not get resettlement. And this was a very politicized topic while I was in Niger. So Nigerian bureaucrats criticized the UNHCR for making Niger into a holding country for people rejected. And they also did not want to keep these rejected evacuees, applicants, because they saw them as security risks. And in fact, there were a lot of everyday security issues concerning these evacuees, because they had like often serious traumatization and had learned that violence is also a measure of making your interests work. So there were a lot of these conflicting issues in the everyday of Nigerian society. Then on the ground, I think I cannot delve too much into that now, but there were a lot of disputed solutions. So what to do with these rejected cases. One idea was residence in Niger, but then also Nigerian bureaucrats said they did not necessarily want it. They sometimes claimed that they would deport people back to Libya, which was of course against UNHCR ideas or positions on the return to Libya. UNHCR developed complementary pathways, and I could also observe that there was a bit more of a lenient RSD practice and resettlement decisions than it would be usually the case. So vulnerability concerns figured more prominently in the assessment than usually. For the more criminal, like the serious criminal cases, the UNHCR envisaged an extradition to European jurisdictions, but it was also bound to follow first the asylum procedures in Niger and the appeal mechanisms available, but they were not really effective because they had necessarily never been implemented to the end. So the third instance of the High Administrative Court had never been seized for asylum decisions. And the evacuees on their part who had issues in their cases, they took to demonstrations, for example, to public protests. And many of them exited Niger also because they did not find a future in this very poor country. And probably most of them went back to Libya. So we can see that there was not really a protection achieved for these people who then decided to return to Libya. And to jump to the conclusion, I think this is important to see that what are the solutions for rejected cases in extraterritorial processing? Is there any decent solution that can be achieved for them? And I think in this case, this had not been created before the start of the project. And the second point I here want to make is that we should really challenge the post-colonial power asymmetries that are in these types of projects. So we see here Niger actually wanted to have a sole responsibility for the processing, but then it was incrementally disempowered in the process and it became a holding country against its will. What I did not talk about so much now is that contestations by bureaucrats partly also managed to restore their agency despite these important asymmetries. So we see that still there is something like a mobilization from below that can also shape and shift these projects. But I think, and this was in the chat a question, I think these post-colonial power asymmetries need to be scrutinized, and they are really important for the implementation of these projects. Now, if we look at the ETM in Rwanda that was established in 2019, I did not study that, but I read that the UNHCR was responsible for the RSD from the outset, and settlement became an option for refugees brought to Rwanda. So we see two important procedural adaptations in response to how the ETM in Niger was developed initially. And what I want to mention here lastly is that because we had a lot of these discussions that what would be an appropriate standard for extraterritorial processing, I think here it is important to recenter the context that this project was implemented in. So it meant migration control and a severe civil war in Libya, and the ETM intended to restore the access to protection for protection seekers in Libya. But if we look at the numbers of people and the nationalities also, then it only concerned a minority of people in Libya. So for example, West Africans were from the outside excluded from being evacuated to Niger. And these 3,800 evacuees brought to Niger were only a minority compared to those brought back by the IOM, for example, to their countries of origin and to the whole migrant population in Libya. So I think we really need to challenge this idea of that the ETM meant some serious access to protection. Instead, I think we can also perceive of it as a humanitarian border, so a project that provided care to refugees in Niger, but through this care also contributed to and legitimized border control in Libya. So these projects can be inscribed in my migration control efforts. And I saw your case, so I'm at the end. Thank you very much for listening to my presentation.
Thank you so much, Laura. Thank you for your presentation and going into a very specific example of external processing. We have about 25 minutes left for questions and answers. Because we are recording this session as we do every session, I will read out the questions. I do invite the panelists, if they're not shy, to show their faces and open up their cameras. And then I'll invite, once I've read out the questions, I invite the panelists to give responses to the questions or responses to the other panelists, or even pose questions to the other panelists. And then we'll see if we can have a second round of Q&A after that as well. We'll go, in terms of responses, we'll go in reverse order. So I'll ask Laura to go first and then move back Cameron, Nick, and Riona. So first question was around the risk that states engaging in external processing do so in bad faith, that it's rather to avoid responsibility sharing, or and rather to do some responsibility shifting, so not avoid responsibility rather to meet protection needs, and whether the leveraging of the global north, of their economic and political power to shift responsibility to the global south. So that's this power imbalance, Laura, that you've also mentioned. And the question really is, how can we mitigate that power imbalance and ensure that it's not about responsibility shifting, but about responsibility sharing? Then a question around, I'll basically general ask for elaboration on and suggestions for safe and legal pathways, I guess using external processing as protected entry, or as complementary protection, or complementary pathways to protection. Another question again about the importance or the need for political will, cooperation, and action. There will be a lot for that in terms of making this a reality. But what are still some of the key legal gray areas and research points that you see? Particularly, I think that point about what further research needs to be done is an important question for this panel. Or should we be focusing more on activism for action rather than on research? Specifically, Laura, for you, around RSD in Niger, was that done solely on the basis of the 51 Convention, or also on the OAU Convention, 1969 OAU Convention, and the broader refugee definition there? And then a question around specifically again the ATM for you, Laura, as well as Cameron. To what extent was UNHCR supervising and or supporting officials to undertake refugee status determination, the level of oversight, as well as who was managing the process of repatriating rejected asylum claims? Fascinating presentations again. ATM, Niger, and Rwanda. Does this on the ATMs in ETM in Niger and Rwanda, does this have an impact, positive or negative, on other refugees in both countries who are not hosted at the ETMs? I guess this question also goes to the issue that some of you have raised about how does external processing affect the asylum system of the host country. Final question, I'm interested in this conflicting logic between resettlement and evacuations, as both are based on vulnerability criteria. There are scholars who criticize the concept of vulnerability as another power asymmetry tool. In that sense, what is exactly the issue with using the vulnerability criteria in the context of the ETM in Niger? Laura, the floor is yours.
Thanks so much. I'm going to start with the questions on the ETM and then maybe leave the others a bit to my co-panelists. I think, yeah, in Niger, it was both the 51 Convention and the OAU Convention applied for all asylum seekers. So also people from more larger conflict zones were recognized as refugees. And I think bureaucrats actually have a tendency to prefer the OAU Convention over the Refugee Convention from Geneva, but this would require further research. For this question on why was Niger selected as a partner country, it was actually the only country that was willing to cooperate in the ETM. So initially there were other partner countries like Burkina Faso, for example, and I also heard about Morocco and Tunisia, but this was never really confirmed to me. But these countries stepped down afterwards. I think Burkina Faso, especially because of the security issues in Burkina. But Niger showed an outstanding openness to host the ETM. And of course, because of this situation, it also had a bigger leverage to negotiate the terms of the agreement. So I think that's an important aspect for these questions on power asymmetries and the cooperation as well. And of course, it meant a lot of symbolic and financial advantages to the administration in this very poor country. So then again, we see that the power imbalances on the political and economic level really inform which states would be willing to do such an evacuation mechanism or not. For the positive or negative impacts on refugees in Niger, I would say it's very ambiguous. Resettlement was established in Niger also for non-ETM refugees for the first time, actually. So other refugees could access resettlement and also complementary pathways. But this also led to an incentive for people to apply for asylum in Niger because they wanted resettlement, and then a lot of tense negotiations between bureaucrats, UNHCR officials and refugees in the process. So I think the impacts on the ground are, on the one hand, of course, something positive for protection concerns, but on the other hand, they also lead to many new desires and conflicts. For example, state officials did not have access to going to Europe. So suddenly they have to process asylum seekers and refugees who might be able to get resettlement. That's a complicated issue as well for many bureaucrats. And for the issue of vulnerability in the ETM, I think one issue is that, of course, people were only evacuated from Libya when they were seen as vulnerable. I mean, of course, at the beginning, it was all people in detention, so most of them were seen as vulnerable. But people had to perform the role of the very vulnerable refugee to be able to make it maybe out of prison. And I think that's a problematic impact. And the other one is that people were evacuated because of vulnerability, but they were not necessarily refugees. So I spoke to a woman, for example, she had been raped in Libya for a very long time, but then she was in Niger and she was not recognized as a refugee because it was said, well, you left your country of origin because you were poor and not because you had a background as a refugee. So I think these conflicting logics between being vulnerable and being a refugee are still something that's created a lot of these tensions for some people. Yes, I think that's it. I hope I responded to most of the questions, and I leave it to my co-panelists now. Thank you.
Thank you, Laura. Thanks for addressing particularly questions on the ETM. Without further ado, Cameron, over to you for some responses.
Okay, thanks very much. I'll pick a few in no particular order, and perhaps you'll tell me, Case, if I missed something. But let me see. The question about bad faith implementations or use for burden shifting. I would hope it came out in my comments already that I think this is clearly a very real risk, and we've seen ample demonstrations of that. And I think the only thing I'd say to that now is to repeat perhaps the point that this needs to be framed very much as something that can't be put in place from one day to the next. It would require, for it to stand a chance of working, to be carefully planned and invested in, and for the safeguards to be accepted and in place well before moves to any sort of implementation were made. I think there was a question about examples of safe and legal pathways. Others may want to address that a little bit more. I think there were some examples, broadly speaking, given in some of the presentations in terms of refugees and asylum seekers. Obviously the sorts of things that are pointed to typically would be in the first instance, obviously resettlement itself, but also various forms of humanitarian admission, protected entry pathways that we've seen sometimes, even using labourability, mobility programs, and making more use of free movement, regional free movement arrangements that already exist, family reunification, all of these sorts of things. And then I guess that, depending which context you're thinking about, in mixed contexts, you also need to start to think a little bit more broadly about access to regular migration routes in general, and the role of carrier sanctions and all those sorts of things. I think I'll leave it there on that point. The vulnerability point is well taken. I don't think I'll comment particularly more on that. I'm not a resettlement specialist, and the point's certainly taken about the ways in which that can cause problems and perhaps be misused or not be the most helpful framing. But I think the reality is that if you were to implement something like this at scale, you would need some rational and transparent criteria for prioritizing who benefits and who maybe doesn't. And I guess that also ties in with the important question of how what sort of expectations would be raised that might not be realistic for everyone in the course of putting in place some of these sorts of proposals. Legal grey areas and areas for further research. Gosh, there are plenty. I mean, if one that comes to mind, but it's less a bit outside my comfort area in the sense that it's less a legal grey area than something that I think that needs substantially more attention would be the relationship and modelling ways that the relationship could work between extraterritorial processing at scale and the development of national asylum systems, and whether and how that could be made to be complementary rather than at cross purposes. I think in the interest of giving other people a chance, I'll stop there, but obviously there's plenty that can be said on each of the very good questions. Thank you.
Thank you, Cameron. I immediately pass the floor on to Nick. The floor is yours.
Thanks, colleagues. I'll just address a few of the questions. Firstly, to Brian's, which is on the question of risk. I mean, point taken, absolutely. But in my view, the current environment is also full of risk. Title 42 in the US, pushbacks from the EU external borders, Australian maritime asylum has been shut down for 9 years, and even with a change of government will not shift. So the status quo, in my view, is unacceptable. And therefore there is, with all the caveats Cam mentioned, perhaps reason to revisit this concept. My second point on the risk question is that we ourselves have leverage here, both international organizations, but NGOs, and indeed as academics, to support or reject policies that we consider as workable in good faith and based on responsibility sharing rather than shifting. And in my view too, it is important, at least for those who are policy-minded, to set up alternatives to current externalization proposals. So essentially to say to states, well, if you want controlled access to protection, you want to have some control over what you perceive as a irregular migration crisis, here are the elements that are non-negotiable requirements for such an operation. Secondly, to Charlotte's question around legal grey areas and research areas, I could say a lot here, but I think there is, firstly, in very broad terms, room for perhaps a sort of scholarly debate here that is separate from the externalization debate, which is so well established, and also separate from the resettlement and complementary pathways field, which has its own set of researchers. So whether we can think of external processing as a sort of subfield or a relevant academic meeting place, I would be interested in that. And finally, in terms of further research, there's room for empirical research on historical practice around the CPA, the ODP, and more recent practice around the ETMs. Laura has written a wonderful thesis on ETM Niger, but ETM Rwanda is not attracting much attention. And of course, there is certainly room for legal work on questions of jurisdiction, questions of the relationship between external processing and territorial asylum, and indeed national law aspects of such an approach in both destination and partner states. I'll stop there. Over to you, Rihanna.
Thanks, Nick, and thanks to the other panelists for your responses. I thought I'd begin by also just addressing Brian's comment and query regarding, how does one help balance power? I have a few comments about, also bad faith, because I think at the end of the day, we need to deal with certain realities when working with governments in this space. And I think that, I think it would be naive for us to think that governments are purely going to be motivated by humanitarian grounds alone. Governments are answerable to their people and their constituents. And unfortunately, if some of those constituents hold conservative beliefs, the question then is, how do you engage with those people to incentivize and to show them why it's important that we act constructively on migration and to share responsibility, particularly within the global north, because as we know, the vast majority of asylum seekers and refugees are not in the global north. The global north is not experiencing a crisis of numbers. Other countries, many of whom are based in the global south, are experiencing a crisis in terms of numbers comparatively. So that's my one point. But what in terms of, to the extent that there are power imbalances between the global north and south, using these terms very loosely for present purposes, I think one way to mitigate some of the power imbalances and to create some sort of pathways forward on refugee protection is to ensure multilateral engagement, not just between states, but with international organizations, and to the extent possible, refugee groups and advocacy groups themselves. By including as many stakeholders as you can, you're going to allow for a space where varied interests need to be met. And I believe that doing so can help facilitate better outcomes, not just and to balance interests of states, but also people who are seeking protection. And so that's my one point. And this is where and thanks, Nick, for posting my article on the EU and regional processing and looking to the Indo-Chinese CPA as a source of, I suppose, inspiration. But the CPA, of course, was not perfect, and it was within a particular historical context. But it does offer a lot to learn, I think, for a lot of us about how international cooperation can possibly work in practice. And that's why I find it quite fascinating, because it was this interesting arrangement where it involved various interests from states who were being overwhelmed by the numbers of asylum seekers arriving. This is post the Vietnam War. And then you had resettlement states with their own vested interests in this, a lot of it political. NGOs, UNHCR was also involved. So ultimately, the outcome was pragmatic. It wasn't a perfect solution, but it did produce positive outcomes for 2.5 million people who were resettled and 500,000 who were repatriated. And even in terms of the repatriation component, which could be criticized in many ways, and should be, there were also positives that came out of that experience in terms of the EU, for instance, was included significant funding for those who returned to help them reintegrate within the community. And so there's a lot that could be learned from arrangements like that about how one can cooperate internationally and what that might look like in practice. Sorry, I know we're almost running out of time, but that's my, I suppose that cuts across the other question about, well, what other solutions are there, or what other pathways to protection? In the context of large protracted refugee situations, regional processing does offer something to be looked at as a possibility for international cooperation. I might leave it there and hand it over to Kees, just bearing in mind we only have 5 minutes and you might want to do a wrap up.
Thank you, Riona. Yes, we have 5 minutes left and I don't see any further questions in the chat. I'm certainly not going to try and summarize everything that has been said, but maybe using that 5 minutes or misusing my role as a moderator, picking a little bit up on your last point, Riona, and your presentation. I mean, the CPA, is my understanding, indeed was a very pragmatic response to a specific situation, almost a very specific caseload. We've heard from all of you that there is a certain reality that we are faced with right now. The way asylum has been dealt with by the global north, let's say, or maybe even also by the global south, again, whatever that means, those terms mean, is under threat. There are concerns that maybe some form of externalization is a reality that we need to face and that we need to deal with. So I guess my question to the panelists is, would it be possible in a not too long future, in the near or immediate future, to pilot some of the externalization ideas or the external processing ideas, focusing on a specific caseload or a specific situation, using some of the lessons learned from the CPA. That's one maybe a final question to put. The other point, there seems to be in this debate that we are looking at it from a very one-way approach, like it's global north versus global south. But there are also situations within the global north and within the global south where external, where we see mixed and onward movements, and where external processing could actually be used to address some of the challenges. Maybe that's also a point for reflection for the three panelists remaining. Who wants to go first? Nick, you want to go first?
Thanks, Kees. They are two very complex questions, and I'm not sure I'm equipped to answer. On the first one, whether we can envisage a sort of near future pilot of external processing. I mean, I think actually referring back to, I think it was Charlotte's question, who basically asked, you know, is there further work required, or is this a question of advocacy? And I think, to be honest, we're probably at the work phase currently, which is to say there are many questions about feasibility, viability, legal, operational, political questions to be managed. And in light of Brian's question around risk, I mean, we need to have some very clear and developed thinking on what a pilot would look like before naming a specific region or country or situation, in my view. That said, I think, you know, while we're talking in fairly hypothetical terms, external processing to some extent is already happening, as I've already outlined. There are small scale, there are ad hoc emergency schemes. So I think, to my mind, the first step would be some research around what works and what doesn't work, and then applying those lessons learned to a specific situation, which could, of course, be, in the European context, something around the Western Balkans, intra-regionally. In the Americas context, could be looking at a specific caseload around, you know, Venezuelans, Haitians, for example. In Asia Pacific, of course, Australia's newfound interest in the region could open up possibilities around Indonesia, Malaysia, etc., as potential cooperation partners for genuine responsibility sharing. Over.
Thank you. Leona, Cameron, who wants to take a minute? Noting also, by the way, that there is a final point in the chat, and I'll read it out. In discussing and criticizing externalization of asylum processes, I sense a deliberately loud silence regarding the fact that African countries seem to be the test labs for these policies. Comments from the panelist. Riona, you want to go?
I don't think I can cover that question as well in the brief, maybe 30 seconds that I do have, before letting Cameron take over. Sorry, just on the point of you know, what could be done right now, I agree with Nick's comments that there is a lot that is currently happening, and it would be really useful to examine you know, what is working and what is not working. And this is why I found, of course, Laura's discussion really helpful to provide some on-the-ground insight about the practical challenges to implementing some of these processes, which are, you know, were intended to facilitate pathways to protection, and yet they also, again, can be incredibly problematic in its implementation. Thinking specifically about large-scale movements and something like the Indo-Chinese CPA framework, in my mind, I think that a similar framework would only really be the political will to galvanize. A similar framework would require a fairly large movement of people and a sense of perceived crises, whether that's a crisis in terms of numbers or perceived political crisis impacting, and I would imagine it would have to include some global north countries, probably Europe again. So if Europe was faced with, again, another Syrian refugee crisis of sorts, bearing in mind that it was a political crisis, I think that could potentially provide the catalyst for real international cooperation, with the view that Europe would not want to land up in the situation that it was in 2015 and 16. So I do think that there's sufficient political and humanitarian incentives to avoid that occurring again, and for them to work constructively with the rest of the region and other countries that are impacted to share responsibility. So that's my point on that. I might hand it over to Cameron, allowing him some time before we wrap up.
Thanks both, and thanks Case for landing us with a question that could, two questions that could both perhaps require another hour for each of them, and I don't want to beg out, but in the time that's left, perhaps I can say one thing, touching on the point about Africa as a test lab, perhaps not addressing every aspect of that head on. And certainly I'd take that as a comment, and one that would be difficult to in some sense disagree with. And there's a certain political reality there, but theoretically, there's no reason why that needs to be the case. And I certainly would agree with Nick that it's premature to be talking very concretely about proposals for pilots in particular places. But when and if the conditions were right for that, it could be somewhere much closer to the EU, which would have advantages in some sense in terms of implementability, disadvantages in other senses in terms of the claimed policy rationale of avoiding the need for dangerous journeys and so forth. I think we're out of time to go much further into the big questions, but I don't want to lob one big bomb before we sign off, but one thing that's perhaps interesting to think about, and apologies to Rihanna if this is something that you've addressed in other contexts that I haven't had the privilege of being familiar with, but talking about the CPA makes me think also that one thing that needs to be thought about very seriously is the long-term impact of any of these sorts of proposals. And one of the commonplace points that's made about the CPA is the long-term impact potentially in Southeast Asia in terms of an orientation towards a sort of reflex assumption that the resettlement will be the solution, with maybe some impact on the development of national capacity in transit countries. Sorry to chuck that in at the last minute, but I'll stop there. Thanks.
Thank you so much. I apologize for having gone on. Rihanna, sorry, you want to?
Yeah, you probably deserve a right of reply to that. Sorry.
Oh, I do want to, because of course I'm aware of that perception. And actually recently, another colleague of mine, Natasha Yakub, and she's undertaking historical research on countries within Southeast Asia and providing refugee protection. And so I think, based on some discussions I've had with her, at least, and I have to caveat that I have not researched this personally, but I think that the perceptions we have, at least in scholarly literature, on the negative impacts of the CPA, creating a perception in Southeast Asia that, resettlement is the go-to tool, I think is perhaps unfair. When we look at the broader context and the history of a number of Asian countries providing asylum to people. And so what Natasha is currently doing is, I think, flipping the script a little bit on what we've been told. So I would say watch this space and for further research from her. So thank you.
Brilliant. Thank you. Thanks, Fiona.
My apologies to the panelists and to the audience for going over time, but this is a discussion that clearly, for a variety of reasons, will not go away. So maybe we should reconvene next year at the RLI conference. Thank you so much to the panelists, and thank you to all the participants for your questions and comments. Thank you.